Hello and welcome back to our Title IX training series. My name is Dean Shatley from the law firm Campbell Shatley. I'm joined here today with my colleagues Ashley Leonard and Chris Cottle. This is Section 5, responding to allegations. This presentation is designed specifically for Title IX coordinators. Certainly any other administrator wanting to know more about the process is welcome to watch as well. But during this section, Chris is going to walk us through how a Title IX coordinator specifically responds to allegations when they come in, what to do with them if they rise to the level of sexual harassment, or they are made within an educational program or activity, or if they're not. And so at this point in time, I'll turn it over to Chris to begin.
Thank you, Dean. You can see on just kind of a preview slide here where we've been and where we're going. If you're a Title IX coordinator, you've seen all these. And if you are another piece of the Title IX puzzle, the Title IX personnel, you may have seen some, but not all of these. So just as a quick review, we started with sort of the fundamentals, what the Title IX rule is, some basic definitions that apply under the Title IX rule, as well as what the current School Board Association policy looks like, walking you through some of the major changes that the new Title IX rule has impacted in old board policies and new board policies. Then we took a sort of a deeper dive into the distinct roles of each different person involved in the Title IX process, be it the Title IX coordinator, the investigator, the decision maker. We looked at some additional compliance issues related to that. So we're going to kind of take all of that information and hopefully for the Title IX coordinator in particular, show the difference between acting once you receive a report, a Title IX report, versus investigating. We'll have an entire section on how to conduct a Title IX investigation, how to initiate a formal complaint, and how the investigative report ultimately leads into the decision-making or hearing process at the end, depending on the situation. So for now, let's jump right into the start of this one and also take a quick look at the entire process through another chart. So this is the process that we have kind of continued to harp on if you're a Title IX investigator, kind of from the beginning to the very end. Some incidences will be reported, and we'll talk more about the initial response once you receive a report and how that triggers the actual knowledge prong under Title IX. Again, your job as a Title IX coordinator when you receive a report is to do an initial assessment to determine whether or not the conduct, if true, would constitute a violation of the Title IX rule and the Title IX policy. We'll talk a lot more about that in this training, but keep in mind there's sort of an initial assessment there where you're gathering facts, making some initial determinations as to whether or not you can and should proceed. That's different than the later investigation. So once you pass that initial assessment phase and the conduct does trigger a formal complaint, we have a formal complaint, we then move into the investigative phase, which culminates with an investigative report by the investigator who is appointed. And then the final stage is being a decision-making process, which will vary depending on the conduct and an appeals process as well, depending on the conduct. So again, that's the process from a 50,000 feet look, and just keep that in mind in the back of your mind as we go through each of these individual parts in this training. All right, so a little bit more review. I mean, the first thing that as a Title IX coordinator you need to be thinking about, and this is a little bit of a review from the Title IX fundamentals training that you've already had. The initial trigger for when we as a school district need to act to meet our obligations under Title IX is when we have actual knowledge of potential sexual harassment. Remember the definition of sexual harassment. Whenever we have actual knowledge of a report of sexual harassment, then we have to take immediate and appropriate steps to offer supportive measures and determine if an investigation is required or requested. So again, unpacking all that, remember actual knowledge, remember the scope of actual knowledge when that triggers our obligations under Title IX. Remember the definition of sexual harassment. There were a number of different ways that conduct could potentially amount to the definition of sexual harassment under Title IX in your policy. But the important thing that we're going to stress a lot on in this training is the immediate and appropriate steps that you as a Title IX coordinator should take anytime that you receive a report in trying to determine whether or not the process needs to proceed. Another thing we'll talk more about in later slides in this training is supportive measures. These are can be short-term, interim, or measures taken that persist throughout the entire process, which can be offered to the complainant or the respondent, and they're intended to remedy the alleged harassment, and they really kind of serve as a stopgap to support either parties during the process. We'll talk about the scope of supportive measures in later slides. One thing that we want to reemphasize in this training has come up in various ways in the trainings thus far. You'll see it again in later trainings, especially in the investigation stage. Actual knowledge for K-12 institutions, actual knowledge for Title IX occurs whenever the district receives a report of alleging sexual harassment that is received by the Title IX coordinator or any school employee. All right, very, very important that this is a very broad category. So it's not just that you, the Title IX coordinator, have received a report. Actual knowledge is triggered under Title IX when any school employee, be it a teacher, be it an assistant principal or a principal, receives a report with allegations of sexual harassment. So keep that in the back of your mind. We'll talk about that a lot in this training and in later slides, but just always keep in mind that this is a very broad scope for actual knowledge. So one of the other phrases which we have used thus far and we'll use later on in this training and others is the legal standard for liability under Title IX, and that is the deliberate indifference standard. So this is the standard that the school district is held to if it was to receive a lawsuit alleging a violation of Title IX or for compliance purposes. This is a term of art. It's a legal standard that has been refined through the Title IX rule and case law. But essentially, at the end of the day, it really means that whenever we receive a report that alleges sexual harassment, we cannot ignore it. We have to act to try to remedy, we have to act to determine whether or not it's covered under Title IX, and we have to act under our policy in order to determine whether or not an investigation is needed or requested under Title IX. So we can't ignore the conduct. We have to act in order to try to remedy the effects of the sexual harassment in our program or activity. Dean, did you have anything else you wanted to add on sort of the scope of the deliberate indifference standard for Title IX coordinators?
Deliberate indifference is more than just mere negligence. And I think a lot of times school employees are used to the negligence standard. They had a duty to act and then they failed to act. But ultimately, under deliberate indifference, that's basically saying that there was a conscious disregard to act. We undertook the decision to not act at all. And so the Title IX policy, if your district follows your policy and you go through the steps, even if that step ends at, we determined that this does not rise to the level of sexual harassment, then that kind of demonstrates that we were not deliberately indifferent, that we have made an assessment. And if we determine that if the allegations, if true, do rise to the level of sexual harassment, then we investigated it and we went through the decision maker process. So always keep in mind that, deliberate indifference is a high bar, but it pretty much means you're sweeping things under the rug to a certain extent, or you're just consciously failing to act when others would, to protect others too from harm. So it is a high standard, but it is more than just mere negligence.
And it's triggered whenever the district has actual knowledge. So let's look at how the scope of the mandatory reporting of when to act and the deliver and different standards kind of work together. So again, just to reiterate, all employees must report incidents of sexual harassment. So this is, any employee, whether it be a teacher or an administrator or anyone working in the school district, if they receive a report of sexual harassment, that needs to be reported immediately. So the question is, once they receive a report, who do they report it to? We've divided these into the student and employee context. If it's a student matter, then that needs to be reported directly to the principal or the Title IX coordinator. So it could be made to both. It could be made to the principal, and the principal would then need to forward that directly to the Title IX coordinator. It could be made directly to the Title IX coordinator. So at the end of the day, if either one of those, or really both, are preferable to make a report whenever one is received. The same token for employees, those allegations or that report, when received, should be forwarded to the HR director or directly to the Title IX coordinator, or both. But ultimately, keep in mind that the actual knowledge portion triggers when we receive a report, but it's ultimately going to be the Title IX coordinator who really needs to know about this conduct that has been alleged and the report that's been made as soon as possible, because the Title IX coordinator is going to be the one most familiar with the policy, most familiar with the process, in being able to determine whether or not it is actually conduct that is governed under Title IX, or whether or not it's something that might not quite rise to the level of sexual harassment, but could still be covered under other board policies. The Title IX coordinator is going to be the one that will be in the best position to make that determination. So the sooner they know about it, the better. And so, there really should not be much of a lag. I mean, as soon as the report's made, it needs to make its way to either of those decision makers or Title IX coordinator immediately. One kind of issue, and we're talking generally, and I'll open this up to Ashley and Dean, how does the reporting requirement differ, if at all, for certain sort of special employees within the school district, like a school counselor, who may have a privilege that's recognized at law, or have some sort of a confidential relationship with an employee or a student that has given them information that might be a report of sexual harassment?
So a school counselor has a certain privilege with their interactions and conversations with a student. That privilege, though, is very limited, and I think gets extended a lot of times by school personnel, including counselors and administrators. The privilege prevents a school counselor from testifying in a court action or providing their notes in a court action without approval of the judge. So a judge could force a counselor to testify after reviewing all the evidence and having a conversation. And so the privilege is only about the testimony in a court proceeding. So it would not stop a school counselor from reporting to the principal and Title IX coordinator allegations of sexual harassment, sexual assault, sexual misconduct that are told to the school counselor by a student. In fact, the school counselor is not a confidential employee and should make those reports to the principal and the Title IX coordinator. Certainly the school counselor will need to have a conversation with the student, talk to them about the fact that the school counselor is required to report these instances as well. And so we would encourage school counselors to report allegations of sexual harassment, misconduct as soon as possible, so the school district can take appropriate measures. Ashley, anything to add?
I'll just note that under the Title IX regulations, it's very clear that the regulations say all school employees in terms of getting actual notice. The regulations themselves do not create any exceptions in the K through 12 setting for who does not have to report. They are very clear in that all employees, if they receive a report of alleged sexual harassment, give the school district notice of that alleged sexual harassment.
And so I think at the end of the day, the silver lining here, is, when in doubt, report if you're an employee. And this is going to be, a very important training function for Title IX coordinators, particularly with teachers and administrators at the school level, just making sure that they know whenever they receive a report that could constitute sexual harassment, to make sure that that's passed along to a Title IX coordinator so that it can be resolved appropriately through the policy. So one of the other things to consider is, in the world that we live in today with technology, remote learning, social media, it may not be, in determining whether or not we have actual knowledge, and the scope of a report is not just, a written report that is delivered, to a teacher or to an administrator. There may be some situations where, just based on the facts and circumstances, we may have actual knowledge just based on information that is widely available in the media. So, or in the media or in the community. So we could have actual knowledge through social media, print, television, community members, reports, credible reports of sexual harassment at a school or in a workplace that might constitute a pattern of conduct against multiple students. That might be enough for actual knowledge to trigger Title IX. Widespread, openly practiced, or well-known allegations among students or employees. So I think the important thing here is to always kind of look at the scope of our notice as pretty broad, and remember the deliberate indifference standard, and do not just turn a blind eye to reports that we receive and information that is pretty widely known amongst the education community or the workplace.
Chris, I want to reflect on something that I have seen many times since I've been practicing school law. And it has to do with your last bullet: widespread, openly practiced, or well-known among students or employees. You look at that bullet and you're thinking, that's not happening in my school district. How would we ever let that happen? But I can't tell you the number of times where I've been involved in an investigation, particularly of a school employee who may even be facing criminal charges. We're in the process of terminating that employee due to the allegations of sexual abuse that we believe to be true. A lot of times it would be with a student. And then when you start to peel back the layers of the onion during the investigation, you'll see staff members in the school say, oh yeah, everybody in the school knew he was too close to students. Everybody knew he had a special relationship with a different female student every year. Or everybody knew she had a special relationship with a male student or every year. And so, and again, sex and sexual orientation does not matter here. But you start to peel back this onion, and then you hear all these rumors, and then it turns into, oh yeah, we know. And I've even heard people say, well, we told the central office. And I'm kind of thinking, well, what hasn't anything been done? And so when the litigation ensues a year or two down the road, certainly one of the allegations in the litigation is that the district knew that this employee was engaged in these kinds of practices. And so my point here is, a lot of times the central office doesn't know. And the rumors are all just kind of withheld inside of this particular school building. And so and what's important, I think, for Title IX coordinators to take home here is, if you have any kind of good faith basis that another employee is engaging in some sort of sexual misconduct with a student, or you have any indication that an employee or a student has engaged in sexual harassment or misconduct, you have an obligation to report that to the Title IX coordinator, who is a central office employee. So you have to report it to the central office, and now you have this person who is guaranteed to analyze it, determine whether or not it fits the definition of sexual harassment, and if it does, then do something about it. If not, and if it doesn't, then the Title IX coordinator can push it to another administrator who can do something about it. And so you don't read these bullets. If you're a Title IX coordinator or school administrator watching this, don't read these bullets and be like, oh, well, this will never happen. It happens all the time.
Let's take a look at a hypothetical and see how some of these principles work out. So in this one, Mr. Doe is a high school teacher. After class, one of Mr. Doe's students approaches him and begins to explain that another student in the classroom has repeatedly made sexual comments to her in his classroom during swim practice and through Snapchat online after school that make her feel uncomfortable and bullied. She asked Mr. Doe to keep this information confidential because the swim team has a big meet coming up. So Ashley, on the first question here, does the school district, based on these facts, have actual knowledge under Title IX?
I would say yes, and I am looking at this through the lens of a Title IX coordinator. So your Title IX coordinator needs to determine if there's actual knowledge of alleged sexual harassment in an education program or activity. Remember, the actual knowledge is allegations of sexual harassment. So you have a student who has come to a teacher who is an employee of the school district of repeated sexual comments made. So to me, that's enough for the teacher to go to the Title IX coordinator to report the matter. And then your Title IX coordinator, having actual knowledge from the teacher, would need to determine if the allegations, assuming that they're true, constitute sexual harassment under one of the three types of sexual harassment in an education program or activity. So that would be the next steps of the Title IX coordinator's analysis.
And another thing, to add on to that, Ashley, for a Title IX coordinator, remember that the conduct that's alleged has to be within an education program and activity. We talked about that in earlier trainings, especially in the Title IX fundamentals. In this instance, as Ashley just pointed out, the report indicates that the alleged sexual harassment has been happening inside the classroom and at swim practice, which would be an extracurricular activity. Certainly the classroom and the swim practice, as an initial matter, would fall within the program or activity requirements under Title IX. But Ashley, help Title IX coordinators understand what about this conduct that's also alleged vis-a-vis Snapchat online through a social media platform that's outside of school, not within the context of the class or the swim practice.
So if it was just that conduct, if it was just Snapchat online after school, that would not be considered an education program or activity because it's not part of the school's operations or on school property, or assuming it's not in a building owned or controlled by the school. But the fact that sexual comments are being made in the classroom and during swim practice, that conduct could be investigated if the Title IX coordinator determines that it rises to the level of sexual harassment.
And these are the types of, difficult factual, situations that as a Title IX coordinator, you're going to have to sort through whenever you receive reports, figuring out if the conduct, even taken as true, would it be covered under Title IX? Did it occur in an education program or activity? Some or all the conduct may or may not have. So this is the initial sort of assessment that a Title IX coordinator is really going to have to spend a lot of time on pretty fast whenever they receive a report. So I think, Ashley, you mentioned that the teacher here should immediately report this directly to the Title IX coordinator, or even to the principal, or both. Now, I'll open and I'll ask Dean this one. I mean, what do you make of the student has asked Mr. Doe for confidentiality? Can he not give that confidentiality to the student?
No, he cannot, Chris. Mr. Doe must inform the Title IX coordinator. Most likely, Mr. Doe should also inform his supervisor, the principal or assistant principal, and then go to the Title IX coordinator together. But the information must get to the Title IX coordinator. And so Mr. Doe should tell the student, I cannot keep this information confidential. I know you would like me to keep it confidential, but you're going to have, let me tell the Title IX coordinator. The Title IX coordinator will have a conversation with you about the process, about how you can move forward or choose not to move forward, because it'll always be up to you it'll always be up to the student on whether to file a formal complaint or not. There are some instances where the Title IX coordinator can issue a formal complaint without the complainant's consent, but most likely it's going to be up to the complainant himself or herself, in this case herself. So think about that and find out a way that, the teacher needs to find a way to talk to the student that makes the student feel comfortable. And Mr. Doe is not going to run around the school building saying that this student has made some sort of sexual harassment charge. It's going to be kept confidential in a very small circle of people initially. And so that's something I think that could hopefully set the student's mind at ease a little bit. So that's the conversation, or some sort of conversation like that Mr. Doe should have, but he cannot keep it confidential.
And these are, can be difficult conversations for a teacher like Mr. Doe to have, but it's important that teachers understand that their knowledge is attributable to actual knowledge under Title IX, and that they really don't have the option of keeping it confidential, even if the student has requested it. So being very clear with the student is the right way to go in this situation. All right, so let's look a little closer at the distinction here between acting based on a Title IX report and investigating a formal complaint under Title IX, which we'll cover a lot more in detail in the next training. So whenever a Title IX coordinator actually receives a report that alleges sexual harassment under the model policy, the Title IX coordinator has 3 days to do a number of things. So I'll skip kind of down to the very end, and then we'll look at each one of these, in tandem with that. But back to the last hypothetical, your first and, most important thing to do when you get a report like this, or like the one we just looked at in the hypothetical, is to try to quickly make a determination based on the facts that you have as to whether or not the conduct, if taken as true, would violate the Title IX policy. In some instances, you're going to be able to determine right away that it clearly would. In some instances, you're going to be able to determine right away that the conduct might be might violate other policies in the district, but the conduct on its face just isn't enough to reach the definition of sexual harassment. And then certainly you're going to have many cases in between. So the sooner that you can begin to look at that analysis, is going to benefit you, because you don't have a lot of time. So other things that you should do immediately upon receiving a report for Title IX coordinators, you're going to need to engage with, in an interactive process, with the person that made the report, which may or may not be the potential complainant. So you're going to need to communicate directly with the person that made the report and reach out to the complainant to offer and implement supportive measures. We'll talk more about supportive measures in just a moment, but that is a really key part of this, and it's really key in showing that the district did not act deliberately indifferent, that we act appropriately and took immediate steps to try to follow our policy and remedy the harassment if, in fact, the conduct alleged falls under Title IX. So communicate with the person who made the report and the complainant. Again, depending on how you got the report, if it was made directly to you, you'd want to notify the principal if it was a student matter, or the HR if it was an employee matter. If it came directly from the principal or the HR, certainly you may need to keep them in the loop in terms of that you've received the report. But if it came directly from them, just keep that in mind. Offer and implement supportive measures. The other key component in the immediate steps of acting when we receive a report is when we're reaching out to the complainant, sharing the school district's Title IX policies and procedures and explaining in pretty deep detail what the grievance process looks like for a complainant. And, if it's a student, their parent, giving them the information they need, giving them the policy and explaining what the steps of a formal grievance process would look like and how filing a formal complaint would initiate that process, explaining their options of how this conduct would be dealt with through that process is very, very important so that they have an informed decision, because it's ultimately the complainant's decision as to whether or not they want to utilize that formal grievance process and make a formal complaint under our Title IX policy. So each one of these steps needs to be done fairly quickly. This is an important part of the process on the front end to make a determination to see how to proceed. And after you've done each of these things, cannot stress enough to you under policy and good practice, document what you are doing and to be able to show to anybody, on the back end of this, to be able to justify our process, what we did, why we did it, and how we did it within a reasonable time frame to show that our actions just were not deliberately indifferent.
And one of the important things for the Title IX coordinator to do from the very beginning is to create a timeline. And this is why Chris is reiterating document, right? And so the Title IX coordinator should very much keep a timeline of events as they happen in course of the policy. Certainly let the investigator create the timeline of how the sexual harassment took place. That's not what I mean. I'm talking about keeping a timeline of, this is when the report was made to a principal. Principal called me on this date and time or emailed me. I corresponded with the complainant's parents on this date, asked them to come meet on this date, etc. So get all of that factual information and what occurred. And really the Title IX coordinator has got to be a good file keeper. They have got to maintain and keep up their file and records and be highly organized in that regard.
And keep in mind, again, this, although the Title IX coordinator is conducting a number of steps here that include some initial fact finding and some reaching out that will, necessarily involve, hearing some of the alleged facts, this is different than a Title IX investigation that is conducted by an appointed investigator, which culminates in an investigative report. Very distinct and separate from that. But there just are parts to this that the Title IX coordinator has to handle on the front end to be able to move forward appropriately. All right, so let's look at a second hypothetical here, put some of these principles in practice. In this one, a principal learns that a male student has complained that a female student has been sending sexually explicit text messages to him. The male student reported that the text messages make him feel uncomfortable and he doesn't want to come to class because the female student is in the same class. So those are the facts. And then the principal talks to the female student who admits the conduct, and the principal suspends the female student for 2 school days. A week later, the male student's parent contacts the principal, tells the principal that they don't believe the school has done enough under Title IX to remedy the situation. The parent tells the principal that they want to file a formal complaint on behalf of their son. So, Dean, I'll start with you. As the principal receiving this correspondence from the parent, what should the principal do first, and what should come after the initial receipt of this complaint from the parent?
Principal should get ready to have a letter of reprimand put in his or her personnel file for not following the Title IX policy. So the first two bullets that lead us all the way through the conduct up until the principal suspends the female student, the respondent in this case, for 2 days, that's the old way of doing it, right? So the new way of doing this is completely different. But let's take this in two steps. What should the principal do now that the parent has contacted the principal and says they want to file a formal complaint? The principal should pick up the phone and contact the Title IX coordinator and then send an email to the Title IX coordinator to follow up. So they need to make both contacts with the Title IX coordinator to put the Title IX coordinator on notice and then let the Title IX coordinator take it from there. One of the big issues here, though, is that the principal should have contacted the Title IX coordinator back in the first bullet before the principal suspended the female student. And this is something we'll talk about here and later on, and I'll certainly let Ashley come in on this part of it too, but suspension for conduct that is potentially subject to Title IX cannot occur until the Title IX policy has had the ability to run its course. And that may be, they get to the Title IX coordinator and the Title IX coordinator makes an assessment that it doesn't rise to the level of sexual harassment. So then the principal can give discipline or render discipline. But if the Title IX coordinator says, yes, if true, this would be subject to the Title IX policy, so I'm going to start an investigation, that sort of thing, and begin the process, we're going to have to potentially wait. And we'll talk more about that as well during the emergency removal section. But the last point I will point out is if the Title IX coordinator starts an investigation in this situation, the principal who has already rendered discipline to the female student may be conflicted out. And the reason is because the principal's biased. The principal has already made up his or her mind as to the responsibility of the female student, the respondent in this case. And I'm using responsibility, interchangeably for the word guilt here, or culpability. And so the principal already believes that the female student is culpable. And maybe she is, but the investigator has to look at this through an objective lens at the beginning of the investigation and throughout the investigation.
And again, I think, Dean, just that what this hypothetical reiterates again is, training for your principals and your assistant principals, making sure at a minimum they know who the Title IX coordinator is, they understand the Title IX definition for sexual harassment, and they are able to forward these types of situations onto the Title IX coordinator in a timely manner on the front end to avoid any potential issues on the back end whenever there's a secondary whenever the Title IX investigation or analysis begins. All right, so we've used this term a couple times. Let's dive into it a little deeper here. So supportive measures under Title IX are, and you can see the broad definition here, and we have some examples here for you, but non-disciplinary, non-punitive, individualized services that are offered as appropriate and as available without fee or charge to either party, the complainant or the respondent, before or after the filing of a formal complaint, or even in an instance where no formal complaint has been filed. So if you think back just a couple of slides, one of the first things as a Title IX coordinator that you're going to do when you receive a report of alleged sexual harassment, again, you're going to contact the person that made the report. You're going to contact the alleged complainant as well. And one of the things that you will do, along with providing the school district's Title IX policy and explaining the grievance process, is offer supportive measures. Now, these are just a couple of examples of supportive measures, and this could again be in the student context, or it could be in the employee context. That you're going to offer. Now, supportive measures, if they are accepted, can be implemented immediately, and they can continue throughout a formal complaint process. And to the extent that it's needed and an investigation occurs and a formal complaint is filed, Supportive measures also should be offered to the respondent, also, on an equal basis as well. So types of supportive measures that you're going to likely see or want to offer are things like counseling, mental health services referral, extensions of deadlines or other course-related adjustments. Again, um, sexual harassment is a very serious thing. So to the extent that a complainant or a respondent has been impacted by the conduct, things like extensions of deadlines and course-related adjustments are helpful to maintain the status quo and preserve equal access to the education program while the grievance process is being followed. And we'll talk about in later trainings how this, when we get to the investigative phase, if it goes that far, can sometimes be a lengthy process. So supportive measures are critical during sort of the pendency of the grievance process. Same token, modifications of work or class schedules that could apply for both an employee or a student. Then we get to things like escort services and mutual no contact orders. Again, that's going to vary on the facts of each case in extreme circumstances, especially if there's been some sort of physical violence alleged or some sort of physical contact or intimidation. Certainly things like escort services may be appropriate to maintain the status quo of the education environment or the work environment. Mutual no contact orders can be very helpful on the front end in order to just if depending on the type of harassment that is alleged, making sure that the two individuals do not communicate with each other and that there are consequences that can be enforced by the school district if their ongoing communications continue. So always consider a mutual no contact order. When you're looking at supportive services in the employee context, things like changes in work environment, leaves of absences, increased security and monitoring. These are all just examples of supportive measures that you could put in place for students or employees on the front end or back end of your Title IX process. Keep in mind for things like mental health services, again, we can't mandate that. We can make a referral for mental health service evaluation. We can't mandate that that's taken, that happens during the process. But at the end of the day, the supportive measures, the implementation and the maintenance of them are a key part of showing that the district was not deliberately indifferent when it received a report under Title IX. All right, so now let's kind of transition from the Title IX coordinator's responsibility to act whenever it receives a report and the actual investigation that would ensue from a formal complaint. So again, the essence of the question that the Title IX coordinator has got to determine on the front end is, do the allegations in the report as stated constitute a violation of district policy, that taking in consideration all the definitions that we've talked about in previous trainings? If the answer to that question is yes, then the complainant has a decision. That the complainant needs to be informed of what the district's process looks like, what their options are under the process, what likely outcomes, not likely in terms of defining responsibility, but what types of outcomes could happen through that process. And the complainant, and if it's a student along with their parent, has to decide whether they want to pursue a formal investigation. And to do that, they have to file a formal complaint. So if you get a formal complaint, then that will trigger the start of the next process, which we'll discuss in a later training. And that's the formal investigation process. Now, the trickier option here is whenever we have analyzed it, we think that the conduct as alleged would constitute of a violation of Title IX, but the complainant, after being told and having the process explained, just decides they don't want to file a formal complaint. So then the question becomes: is the nature of the conduct that was alleged, the type that the school district must investigate regardless of the complainant's wishes. So again, this is sort of a secondary consideration for Title IX coordinators only whenever a complainant does not want to pursue a formal investigation and sign a formal complaint. So let's look at some of the factors that the school district and the Title IX coordinator would need to consider in whether to proceed or not. And again, this is highly fact-based on each individual case. This is something as a Title IX coordinator you would want to be having conversations with your local board attorney about, to try to figure out the factors and how any of these factors may or may not apply as to whether or not the school district wants to proceed with an investigation. So certainly the two biggest areas are, you look at the severity of the conduct and really the frequency of the conduct. In some instances, even, and really in all instances, one allegation of rape or of sexual assault, that's going to be serious enough that even if the complainant doesn't want to proceed with a formal complaint, the school district is going to have to look very seriously at conducting its own investigation, because that could have wider application to that student in the education community and other students in the class and the school, or in the employee context as well. Frequency of the conduct matters. The higher the need, the higher the frequency, the more need there is to conduct an investigation, even if a complainant doesn't want to proceed. Certainly things like we talked about earlier, if there is long-standing, widespread knowledge that a particular person has sexually harassed multiple people over long periods of time, that's the type of conduct that once we know about it, we really need to continue and investigate, even if we have a complainant that doesn't want to move forward. So I think the take home on this slide and this issue is it's going to vary from case to case, highly fact-based, and this is a difficult decision for a Title IX coordinator to make a determination on, and you need to seek advice from your local counsel if you're looking at a very complicated fact pattern. Dean, Ashley, do y'all have other thoughts for Title IX coordinators that are going to engage in this analysis?
I think the one thing for a Title IX coordinator to remember is, simply because a complainant does not want to file a formal complaint does not relieve the district of its obligation to do something about sexual harassment and misconduct. For instance, if a rape did occur on campus, we have to address it. Common sense. Title IX does not give us an exit to not address this behavior simply because the complainant doesn't want to file a formal complaint.
I would just echo what Dean said, because remember that the district's standard for liability purposes is deliberate indifference. So even if a complainant does not want to move forward with a formal complaint, in some instances, if the district uses that as an excuse to not move forward, in subsequent litigation, the district could be seen as being deliberately indifferent to sexual harassment. So keep that in mind.
And also keep in mind that, trying to do this analysis, there certainly may be instances where the district decides that if they don't have a complainant, that it doesn't warrant an additional investigation. And in that case, the Title IX coordinator would be forwarding this, the alleged conduct back through HR or the school level disciplinary process to see if there are violations of other codes of conduct or board policies. But I think that at the end of the day, this is a decision the Title IX coordinator has to make, and it's going to vary greatly on the facts and the circumstances. So make sure you spend some time in each case. So let's look at how the process continues if the district does receive a formal complaint. So again, a formal complaint is what triggers the formal grievance process under the policy. You should have a formal complaint form that your district uses, and it can be, changed based on the facts of each case, but the form itself can be reused. The formal complaint can only be made by a complainant or the Title IX coordinator in the situation we just described in the last slide. Title IX requires and local policy requires that the formal complaint shows the name and address of the complainant and their parent and guardian, a description of the alleged sexual harassment. So, the facts and circumstances that were presented in the report that will be investigated need to go into the formal complaint. There needs to be a request to investigate. And again, a signature at the bottom of the complainant or the parent and guardian has to be in the formal complaint to proceed with the formal grievance process. So this is a form that you should create and also consult your local board attorney in creating this type of a form that can be reused in each of your cases, but will address the specific facts of each individual case as well.
Chris, I want to kind of bring all of this together now. You've gone through the process from when a principal or teacher reports to the Title IX coordinator some conduct that might rise to the level of sexual harassment under Title IX, and the steps that the Title IX coordinator is supposed to do up until that time. And most of those steps are procedural steps. They give notice they bring the complainant in or give notice to the complainant. They meet with them. They talk to about a formal written complaint, and this is what a formal complaint looks like. But one of the more subjective, or not subjective, but one of the harder decisions that a Title IX coordinator is going to have to make is an analysis of whether or not the alleged conduct rises to the level of sexual harassment. And you've covered that, but I want to underline that for everyone, please remember there are three parts to the definition of sexual harassment. Quid pro quo is the first part. The third part is sexual assault, dating violence, stalking. That's the third part. Both of those are real easy to figure out if the alleged conduct fits one of those. The second part of the sexual harassment definition, though, is the one that's a lot more elusive. That is the severe, pervasive, and objectively offensive conduct. And that's going to be tough for a Title IX coordinator. Sometimes it's going to be tough for a Title IX coordinator to determine whether or not that conduct rises or the alleged conduct rises to that definition. But I do want to point out that the Department of Education, in its comments to the Title IX rules and regulations, stated that it must be pervasive. It must be throughout, must be very severe or harsh, that the intent was not just to punish or was not to punish verbal conduct or punish protected speech, and it wasn't to protect or to punish stray comments under the Title IX policy. And so you have this commentary from the Department of Education that seems to be geared much more to higher ed institutions than K-12 institutions. But in order to get to some places where school leaders can discipline respondents, or you may have to figure out, the Title IX coordinator is going to have to figure out early on whether or not this conduct meets the definition of sexual harassment under Title IX. Sometimes it will, sometimes it won't. And in some of the other sections, we've discussed, or we will discuss, how there might be a lot of complaints that come to the Title IX coordinator, and those complaints get closed because they don't rise to the level. I would rather have the Title IX coordinator make a complaint or close a complaint because the alleged conduct doesn't rise to the level of sexual harassment than it failed to be reported to the Title IX coordinator at all. So remember, the Title IX coordinator makes that assessment, not the school administrator.
Just a real quick note on, the receipt of formal complaints, again, triggers the formal grievance process under the policy. One thing that Title IX allows for Title IX coordinators to do, you can, if you've got multiple complaints the allegations are all sort of surrounding the same facts and circumstances, or if you have multiple complainants making allegations against one respondent, or one complainant and multiple respondents, Title IX does allow Title IX coordinators to consolidate formal complaints. It can be helpful in expediting the process in terms of streamlining the investigation part of it and doing the interviews and having it all in one consolidated proceeding. Each of the complainants is still their own individual complainant, but in terms of adjudicating this through the grievance process, you may find that it's helpful to consolidate multiple complaints into one process. Ashley, are there any downsides to doing this?
Any downsides? I think you'd want to keep in mind that as the process moves forward, and particularly if you have a live hearing under your board policy, there's potential for confusion just with multiple complainants or multiple respondents. But I think the efficiency in streamlining the process, as you pointed out, outweighs any potential confusion that could possibly occur later on in the process.
All right, so let's now look at a topic that has a couple of different applications to this process and is something that the Title IX coordinator is going to need to consider in each individual case. So Title IX has one of the terms that it uses quite frequently is emergency removal. And again, one of the hallmarks of the new Title IX rule that is kind of embedded in the rule throughout is equitable fairness and due process to both parties, including the respondent, throughout the entire grievance process. So once you receive a report and that report turns into a formal complaint, always keep in mind that the discipline part, whether or not there was a violation of Title IX, the process has to unfold and the determination of responsibility is not rendered until the very end of the process. And that at that time is when any sanctions, which might include some sort of discipline under the Title IX process, as well as a suspension for that conduct, that all of that happens at the end of the Title IX process. So the emergency removal is something that can take place. Title IX does allow for the emergency removal for a student under certain conditions while the process is unfolding. But it's very specific and it requires an individualized assessment. So a district is permitted to remove a respondent from school on an emergency basis if a threat assessment team, so this is not the Title IX coordinator's decision, this is a collaborative one through a threat assessment team. That team undertakes an individualized safety and risk analysis, and the team determines that the respondent poses an immediate health or safety threat to any person, could be the complainant or anyone else in the education community. Then that student can be removed on an emergency basis during the pendency of the Title IX process. This is something that the respondent has to be given notice of whenever a threat assessment is going to be undertaken, and they have to have an opportunity to challenge the decision immediately following the removal. So let's unpack that a little bit more, and Dean and Ashley, y'all chime in as well. So I think the first question is, how significant does the conduct have to be in order to meet this emergency removal standard under Title IX?
I think it needs to be very significant conduct. The standard that the Title IX regulations give are that the respondent must pose an immediate health or safety threat. So unless you have that immediate threat, emergency removal is not something that should be considered.
And Chris and Ashley, this brings up a great point. So respondent is alleged to have sent some sexually harassing text messages or social media messages during school to the complainant. The parent wants to file a formal complaint. We talked a little bit about this in a previous hypothetical. the parent files a formal complaint. It's been a couple days since the conduct occurred. The Title IX coordinator is assessing the conduct, trying to set up a meeting with the parent and the complainant. And the complainant is really upset. The complainant's parent is upset. They said, why hasn't the student been suspended yet? And the Title IX coordinator says, because you filed a formal complaint. And this is where I think Title IX coordinators and administrators have to find the efficiencies of the process. They have to kind of talk to the parent about what a formal complaint potentially means. And so what would potentially happen, the entire process of a formal complaint, and what would happen or potentially happen if a formal complaint isn't filed. For instance, just because you don't file a formal complaint doesn't mean that the conduct is not addressed by the school administration. It just means that we will not go through this process. And so you have to kind of determine what would be more maybe satisfying to you as a parent and a complainant potentially as well. So keep that in mind. I think it's very important to understand that in a situation where emergency removal would not be justified, the respondent might still be at school with the complainant. Now, the Title IX coordinator may put in supportive measures, like a no contact order, but still going to be there. And the complainant's parents might be upset about that.
So, I think that keep that in mind. Understand that, there is the ability to remove a student after a report of sexual harassment is made and a formal complaint is filed. This is something that is at the school district's disposal, but it is a fairly high standard, and it's an individualized risk assessment and threat assessment that has to be undertaken before there's any emergency removal. Now, when we contrast that a little bit to the employee context, it does not require the individualized threat assessment that it does under the student context. For employees, whenever they receive a formal complaint or a report of sexual harassment, the school district is allowed to place an employee on administrative leave, suspension with pay during the pendency of the grievance process. So while this is being sorted out by the Title IX coordinator, and certainly if there is an investigation, the school district is allowed to put that employee who is a respondent on leave during the pendency. So try to make a distinction there, if you're a Title IX coordinator, between the student and the employee context.
Just a note, Chris, for employees, the school district still has an option of emergency removal for Title IX purposes for employees. If you choose to do an emergency removal, you must undertake the same individualized safety and risk analysis for employees. In lieu of an emergency removal, you can put employees on administrative leave. So Title IX has given school districts two options for employees: emergency removal or administrative leave.
Again, these are all things we just talked about in the last slide. Consider whenever you institute an emergency removal, the types of things that the Department of Education would consider an emergency removal. Could be a suspension of any length of time. It could be a transfer of a student to another alternative education program. It could be a schedule change. So, very, very important there. Consider whenever you are looking at supportive measures, you're not just immediately moving the respondent from an individual school or an individual class based on the filing of a formal complaint. But it may be that as a supportive measure, the complainant may want to move one of the classes that they're in. They may want to move themselves. That's all something that needs to be considered and explained with the complainant on the front end if that is a supportive measure that they are requesting. Removal of a student from an extracurricular activity is the same thing if it's not considered a supportive measure. So, I think just exploring the scope here really any sort of, any one of these things would be considered an emergency removal. And remember the requirements you have to go through if you're going to remove a student on an emergency basis.
Chris, let me ask you a question, and Ashley, feel free to chime in here, but we've talked earlier about a principal holding off on administering discipline before the Title IX process has run its course. This is what the Title IX regulations and new rules say, which can be very difficult for K-12 folks to understand, because typically school administrators are very quick to administer short-term suspensions to students who have engaged in misconduct. They know how to get in there, investigate, and then render a decision. So when can a principal or assistant principal suspend a student before the completion of the Title IX process?
I think one of the ways, one of the clearest ways is if you are able to separate the Title IX conduct, the conduct that alleged would be considered sexual harassment. If you're able to separate completely that conduct from other conduct that was interrelated, then I think you can go ahead and discipline them for that other conduct. So one of the, maybe an easier example is if the principal received this report and they were immediately forwarded text messages and they reviewed the text messages, and the text messages, seemed to show some evidence that sexual harassment occurred. But right along with that, there's also text messages that clearly show a drug transaction, or that the student had a weapon on campus. Those are pretty clearly distinct. So although you would need to follow the reporting process and the grievance process for the sexual harassment allegations, dealing with the drug, the drug conduct is pretty distinct, and you could look at going ahead and addressing and suspending just on that, on the drug offense separately. But it really needs to be very clearly distinct, and this is a difficult area of the new Title IX rule, and it's a big change for K-12 administrators. So I think in each one of these cases, if you don't feel like you're able to completely separate that conduct, you need to reach out to the Title IX coordinator. If Title IX coordinator needs to contact their local board attorney for advice on the facts of each case.
Yeah, and I would just add, Dean, that one of the underlying principles of these new regulations is that respondents are presumed not responsible for alleged misconduct until they've been given all of these due process protections. And so the Department of Education's purpose in creating this timeline of report, formal complaint that needs to be investigated and adjudicated by a separate decision maker, it's all to protect students and employees from being harmed in some way for conduct that that the school district cannot prove that they did. So that presumption of not responsible is why school districts are prohibited from disciplining students and employees prior to any final decision.
There are a lot of frustrating parts about the application of the new Title IX rules and regulations to K-12 institutions. This is maybe the one that frustrates me the most, because principals are very used to getting in there, figuring out what happened, and then rendering discipline as appropriate in accordance with the student code of conduct. And the new Title IX regulations really prevent that from happening. And that's okay. It's frustrating to me, but it's okay. It's just principals have to realize that if sexual harassment, sexual misconduct's involved, you need to kind of put the brakes on and send it to the Title IX coordinator first. Now, in many instances, where the conduct would just have related or just rendered, excuse me, where the conduct would just normally result in short-term suspension, that might not rise to the level of sexual harassment under Title IX, the new rules and regulations for Title IX. But still, somebody needs to make that determination, and it's not going to be the principal, it's going to be the Title IX coordinator. And so what principals need to know is they've got to call a timeout before short-term suspending some students and consult with the Title IX coordinator first and let it go through the process, even if it just gets closed at the very front because it doesn't, front of the process because it doesn't meet that definition. Thank you all for chiming in. Again, this is one of the most complicated and grayer areas of the policies and the new rules, but Ashley's right. It is meant to provide substantive due process rights to the respondent, so the respondent is not deemed responsible until the process has taken place.
All right, a couple of last things following up on emergency removals. Key question here, does there need to be a formal complaint for the district to remove a student under Title IX policy? No. Again, emergency removals can take place regardless of whether there's a formal complaint that has been filed. One other very critical thing to consider when you're looking at the potential of doing an emergency removal based on a report or a complaint that you've received is whether or not the student who would be removed, you have to consider the totality of other laws that may protect that student, primarily among them being individuals or students with disabilities. So the student has an IEP, the student has a functional behavior or a behavior intervention plan. Those are things that need to also be considered as to whether or not, before you can remove the student and do that threat assessment, is the conduct that was alleged, is it a manifestation of the student's disability? That is, of course, a separate process under the IDA, which school officials are familiar with, that would further complicate the school's ability and the necessity of removing a student on an emergency basis. So make sure that you keep that other factor in play and remember it as you are looking at each one of these individual cases. And don't forget also that anytime that a school decides to conduct an emergency removal on an emergency basis, that the student, the respondent, is entitled to notice of that removal and opportunity to challenge the decision in an informal hearing. So, Dean. All right, let's look at one final hypothetical. So kind of bringing some of these principles in play here. Last Friday, 3 teachers all met up at a local bar and restaurant after chaperoning a school dance. On Monday morning, one of the teachers called out sick from work. On Tuesday, the same teacher contacted the district's Title IX coordinator and reported that they were sexually assaulted by another teacher in the group late into the evening on Friday. The teacher indicated that a report was made with local law enforcement. So certainly this is a serious situation, but now the Title IX coordinator is the one who's received this report from the teacher. So Dean and Ashley, as an initial matter, how should the school district respond to the report?
Well, if it's the Title IX coordinator who receives the report, the Title IX coordinator should be able to handle it pretty quickly, in that the alleged sexual assault did not occur on school grounds or school property or in any other type of education program or activity. So even though sexual assault is a type of sexual harassment under Title IX, and the Title IX coordinator has given the school district actual knowledge of the alleged sexual assault, because it did not occur in an education program or activity, it does not fall under the Title IX coordinator's jurisdiction. So the Title IX coordinator should facilitate coordinating a district response between the teacher who reported the incident with human resources, as it's an employee matter and should be dealt with immediately by the district, just not under the Title IX grievance process.
And what about the teacher who was accused of misconduct, the one who was alleged to have sexually assaulted the reporter? What about that teacher? How can they be removed from their duties, and if so, under sort of what provision?
Yeah, so the teacher accused of misconduct should definitely be removed from their duties. Administrative leave with pay while the district investigates from a human resources perspective, because that allegation goes to the heart of a teacher's ability to teach students and the values that the district wants to encourage in their employees. And so that teacher should be removed under a different board policy while the district investigates.
And I think one of the, the sort of the point of this hypothetical is to acknowledge that certainly this is a serious situation here, and Title IX coordinators are going to be receiving reports in all shapes and sizes from employees that relate to employee conduct and student conduct. But there are certain situations, while the severity is not challenged here, there are certain other processes. Title IX is not going to be able to resolve or govern every single situation. So in those situations, it's important to look at, for Title IX coordinator's perspective, situations where a Title IX coordinator has to close a report, or if they've received a formal complaint, there may be situations where they're required to close that report or that complaint. And then there are some situations that you might encounter as a Title IX coordinator where you're not required to close it, but based on the facts and the circumstances of the case, it may make sense to do so. So the two mandatory ones kind of go to the heart of the last hypothetical. If you receive a report or if a complaint is filed that the allegations stated, even if they're true, would not constitute a violation of a Title IX policy, then that needs to be closed, and it needs to be referred to other more appropriate parts of the education system or the employment and personnel process as well. And again, the last hypothetical we looked at was a prime example of conduct, which, if true, would be sexual harassment. And it certainly was triggered actual knowledge because the Title IX coordinator received the report, but it did not occur in an education program or activity. Therefore, Title IX process for the school district just really does not have jurisdiction. Some other, issues where a Title IX coordinator might want to consider closing a complaint or a report. Certainly, if the complainant decides for whatever reason throughout the process, maybe they filed a formal complaint, they got part of the way through the investigation, and for whatever reason they decided they wanted to withdraw that formal complaint, that is a situation where the Title IX coordinator would need to look at the facts and circumstances. And if there's no other reason for the school district to take on and complete the investigation on behalf of the school district, then that's a situation where the Title IX coordinator may want to formally close the complaint because the complainant has requested it. Certainly situations where the respondent is no longer enrolled or employed by the district, if they are an employee, well, in those instances, a complaint was filed, but in effect, there has been some remedy of the recurrence or the opportunity of a recurrence of the harassment. So if the respondent is no longer there, no longer enrolled or employed by the school district, that may be a situation where the Title IX coordinator looks at the facts and circumstances and makes a determination that it makes more sense to go ahead and close the complaint. The final situation is one where you as a Title IX coordinator may encounter it a lot. So, a formal complaint can be made by the complainant and the investigator follows the grievance process to do the investigation. But in terms of of collecting evidence and gathering sufficient evidence to be able to make a finding under the Title IX policy. If you have a complainant who doesn't really want to participate in the process, or you have a respondent who doesn't want to participate in the process, or witnesses with corroborating information and no one is able to participate in the process, you're going to have limited options in proceeding with adjudicating the complaint. So Ashley, does a respondent have to participate if there's been a formal complaint filed? I mean, does a respondent have to participate in that process?
No, the Title IX regulations state that no one has to participate in the process, including the parties themselves. You cannot compel a student or employee to participate, even if they begin to and then change their mind. So if a respondent doesn't participate, that is their individual decision.
And certainly in instances where, a respondent is not participating, that may, now again, that depending on what the allegations are, if you have allegations made by the complainant and you have interviews and documents provided by the complainant and the respondent doesn't want to participate in the process to rebut those allegations, then if, that and the complainant wants to continue with the complaint, that could lead you to a situation where you feel like you have enough evidence to proceed. So keep these in the back of your head as you are going through the process. There are some situations where you need to close, and we'll talk about how to do that in a moment, but you would need to close a report or a complaint. And then there are some situations where it may make sense to, based on the facts and circumstances, but it's not required under Title IX. Title IX does require that if a Title IX coordinator is going to close a report or a complaint, that there's a documentation function that the district needs to undergo, the Title IX coordinator needs to implement. Both parties have to be notified of the reason for the closure. The parties both have a right to appeal that decision to close. And in the notification to the parties, there should be some directions for how an appropriate district office or department can also resolve the report or the complaint. So this is really a documentation function to shift the process from a Title IX process to another district process, give the reason for the closure, and let the parties both know that they have a right to appeal that closure in each individual case. All right, so let's look at the final option here in acting and investigating. We have alluded to an informal resolution process in other trainings. An informal resolution is allowed under Title IX in almost all circumstances. So really the only circumstance where an informal resolution could not be used by the school district to resolve a Title IX complaint is in the situation where the allegation is an allegation of sexual harassment between a school district employee and a student. Title IX prohibits an informal resolution of conduct based on those allegations, but any other employee on employee or student on student conduct, as an initial matter, you could use an informal resolution to resolve. The one requirement for any informal resolution is that a formal complaint has to be filed. So that is an important piece in looking at what your options are as you move through the process. There has to be an informal complaint filed, and if so, the district could look at informally resolving it. Other requirements, both parties have to agree to it, and they have to agree to it in writing. There has to be written consent by the parties to engage in the informal resolution. Dean, maybe be helpful for you to just give an idea of what does the informal resolution process look like for Title IX coordinators as they're going through it.
So for the Title IX coordinator, the process, and for the parties, it can take different shapes, and depending on the allegations, I think will certainly depend on how the informal resolution takes place. Now, certainly the Title IX coordinator cannot be the facilitator of informal resolution. The Title IX coordinator must assign that to another person. That person may be another administrator. It may be an outside resource. A lot of school districts have, or a lot of counties have mediation centers or counseling centers that could help in this regard. But regardless, you need somebody who is strong and that can help try to get the parties to some sort of agreement. But in regards to what it might look like, it might look like a mediation where the parties meet for a little bit and then kind of go to their own separate rooms with the facilitator going back and forth. It could all happen via phone. The facilitator talks to the complainant, hears the complainant's concerns, then calls the respondent's parents, if the respondent's a student, talks to the respondent about those concerns, hears the differences that are in the stories potentially, talks to both parties about realistic outcomes that would make both of them feel comfortable, that would make the complainant feel safe, and able to enjoy the benefits of being in school and of school programs and activities, and try to reach some sort of resolution. It may be where you can get the two parties in the same room. It may not be a wise decision to get the parties in the same room. So the Title IX coordinator and facilitator are going to have to talk that through about what would be a meaningful way to facilitate an informal resolution between the parties that will help and not do further harm.
And there's a lot of flexibility here, as Dean mentioned. If the parties are willing and will provide consent to engage in an informal resolution, this process could happen over a series of days. This process could happen in a singular day. There's really a lot of flexibility for the district to resolve a formal complaint through an informal resolution if the parties agree to it. And it could be started and could be ended any time. So, an informal resolution could happen during an investigation. It could happen prior to the district's start of an investigation. Could even happen right after an investigation before the decision-making process. So, it really, the flexibility the district has, this may be one of the tools that you are able to use to try to resolve Title IX complaints if you have willing participants in the parties throughout the process. Couple other notes on informal resolutions. If you're going to engage in the informal resolution process, like many other parts of the process, the Title IX coordinator needs to provide notice to the parties that of the allegations of the sexual harassment, the requirements of an informal resolution process, whatever the district's expectations are, and also what the potential outcomes could be for the parties in participating in the informal resolution process. Key there being that both parties are fully informed and willing participants in providing consent to engage in informal resolution. Because absent the informal resolution, both parties have due process rights in the grievance process, which they can access. At the end of the informal resolution can again resolve completely a formal complaint, but in order to do so, it must culminate with a written agreement that is signed by both parties. So that written agreement will spell out how the district is going to resolve the complaint, what the parties have agreed to in lieu of continuing the investigative and the decision-making process. And it will just give both parties an idea of what their obligations and rights are moving forward. But very important is once that agreement is signed, it is non-revocable and non-appealable. So you need to make sure, if you're the Title IX coordinator facilitating, and again, the Title IX coordinator is not the one that would be engaging the informal resolution, but they are sort of overseeing the process. It's very important that the parties understand that once that written agreement is reached, that is the end of the process, and there really is no revoking that agreement, and there is no appeal of it. So even if the facilitator has been working with both parties for days and feels like they have an agreement in principle, until it's signed, it is not binding on the parties. Either party could withdraw from an informal resolution at any time and continue with the formal process that's outlined in the grievance policy.
I have a query for the two of you. Let's assume two students go to informal resolution, and as part of the informal resolution, the respondent admits that he engaged in the conduct alleged by the complainant. And as part of the informal resolution, the informal resolution does not include any provisions about disciplinary conduct, but it includes other supportive and corrective measures for both parties. Once the informal resolution is signed, does the school administration have the ability to then discipline the respondent, since he has admitted to this conduct, which assume is a violation of the student code of conduct?
Do they have the ability to discipline him under the student code of conduct?
Yes.
That is a good question.
That's a tough one, isn't it? And I think my gut reaction is yes, but
I don't think Title IX prohibits it.
Yeah.
But I think you would have a really mad, angry respondent and potentially respondent's parents if you chose to do that. Because if the respondent knew at the time that if he signed the informal resolution, he was still going to be disciplined, that respondent might not have signed the agreement and might have chosen to continue along with the Title IX process. So I wouldn't advise it, but I don't think you're legally prohibited from it.
And that might be a good reason why the facilitator, the informal resolution facilitator, and potentially even school administrators want to make the respondent aware up front. Everything you're agreeing to here, or maybe not up front before it all starts, but during the middle while we're trying to get an agreement in place, everything you're agreeing to has to deal with the complainant here. This will not prevent the principal from taking disciplinary action. And my understanding is if you agree to this, the principal is going to suspend you for 5 days because that's what would be called for under the code of conduct. And the respondent may, with that notice may feel like that's sufficient. I understand. That makes sense. But then if they just kind of comes out of nowhere, I agree. I think the respondent's parents are going to say, hey, this was all wrapped up. So we have to put be very clear up front. And this is nuanced, but be very clear up front that this may still occur, and maybe even get their agreement that it will occur too. So
yeah, you can include discipline as part of
Sure.
an informal resolution agreement. So remember that as well, that could be part of an agreement in some cases, is discipline based on the respondent's admission of the conduct.
And lastly, the last thing I'll say, Chris, is it is so important to have a good informal resolution facilitator in place, because this facilitator can make this process so much more efficient if these matters can be resolved at this stage. And that's where we want to kind of come to an agreement. Everybody can get the matter resolved. It doesn't require an extensive investigation. And certainly it's the complainant's right to do that, and that's not a problem. And we'll do it when we need to do it. But if both parties can walk away feeling like they've been heard and they've been treated fairly and equitably, that's a positive. That sort of is a win-win for everybody. And it is difficult to find win-win in these types of situations. But if you can find the win-win, it's, I think, positive for the district and the parties.
Agreed. Well, that concludes our training on responding to allegations, and thank you for your attention.
Thank you, Chris. This concludes section 5. The next section will take us to the next step in the process, which is the investigation step. So through this point, we've gotten all the way up to making a determination whether the process should continue, if a formal complaint is filed. And so the next, we'll move right into investigations in section 6. Thank you again, Chris and Ashley, and we'll be back.